Hi. Lately, a lot of people on the left and the center left, and even the center of American political life, people in the law field particularly, have been very upset that the Supreme Court seems to have abandoned the pretense that it's a legal institution at all, that it's all pure politics, that they're an activist court. And then the people on the right laugh and say, ha ha ha, now you know how it feels. That's what we always said about the Warren Court, which of course is now getting to be ancient history, but it still seems to loom large in a lot of people's imagination about the court. The right says, oh, they were activists. It was all politics all the way down for them, too. So what's the difference? Ha ha ha. You just don't like it. And that criticism is very uncomfortable for many on the left to center of political life in the United States, especially more people in the center, because I think a lot of them had a naive view of what law was all along. But those of us who are descended from critical legal studies, and there's a lot of us in who've gone a lot of different directions, but those of us who have a kind of a critical legal studies bent, and frankly, most of us are pretty far left. My friends tell me I'm the most far left of them all. But anyway, those of us who descend from critical legal studies don't find this a very troubling rejoinder from the right at all. And I'm going to explain why. And from now on, I'm going to not talk about we, but I, because I want to take personal responsibility for everything I'm going to say. I have always said, sure, law is politics. Law is always politics, always has been, beginning to end. Everything's political. Of course, it's political. I don't even know what it would mean to say it's not political. So, yeah, it's political. But we've also said, and I particularly, especially, have always said, law is interpretive. It's interpretation all the way down. In fact, that's what makes studying law interesting. If it weren't interpretation all the way down, if it was what a lot of my students think of it as just a list of rules that somehow define themselves. God, that would be boring as all get out. I would never have stuck with it. I mean, from a purely aesthetic, personal standpoint, I'm glad it's all interpretation all the way down. But that's what it is. Law is interpretation. So you got to put those two together. Law is all politics, law is all interpretation. How do they combine? Well, some people would say, well, it's political interpretation. No, 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 no. Let's reverse it. It's an interpretive style of politics. It's not just any kind of politics, it's interpretive politics. And remember, to be interpretive, you have to have something you're interpreting. There has to be some material that you're working with. And remember, interpretation is justification and explanation. And there are norms of justification and explanation. Now, some of my colleagues on the left would say those norms are purely social construction, but I don't. I disagree with that strongly, in fact. There are norms of interpretation that are not purely social construction. And I'm going to disagree with that famous adage of Oliver Wendell Holmes Jr. in his, famous work, The Common Law. The life of law is not logic but experience. I may have reversed how he said that, but I mean, he may have said the life of law is experience, not logic. But either way, I disagree. Logic is actually quite relevant to the law, to the interpretive exercise. And that's where I diverge quite a bit from some of my colleagues on the left. But anyway, that doesn't matter. What matters is anyone, whether you think it's pure social construction or you think, like me, there's something beyond just what we make up as a kind of a convention. There are norms of interpretation, there are norms of justification and explanation, which allow one judge or one lawyer looking at what a judge did to criticize the previous judge on shared grounds. Both judges share these norms of justification and explanation. And that's where what's going on in the Supreme Court now isn't law anymore. They're not doing interpretive politics. They're doing fiat politics. Fiat, what I say goes politics. Which is kind of, it's what Congress does. But, we elect them to do that, right? If Congress says we're going to build a highway, well, they don't have to justify and explain that. They sometimes do, but it's not the same kind of justification. They don't look back at previous building blocks and say, putting them together, the logical conclusion is a highway here. No, they just say, we want a highway, let's do it. That's fiat politics. The court is now doing fiat politics rather than interpretive politics. And I'm not saying conservative opinions are always not law. No. Let me give a concrete example. One of the most famous conservative opinions was Plessy v. Ferguson from the 19th century, where essentially they enshrined segregation in the law, which took decades to overturn. That was really, really bad law, but it was law. It was a legal decision. It engaged in interpretive politics, and it attempted to follow the rules of just the norms of justification and explanation within that form of interpretive politics, and thus was subject to criticism by later interpreters who could apply the same norms of justification and explanation. For instance, an implicit factual assumption. See, one of the norms is we rely on facts, and an implicit factual assumption in Plessy v. Ferguson was that races are real and they're different, and one of them's not as good as the other. Or some of them not as good as the one, which happens to be, the lightest one. But that's a factual claim that can be attacked factually. If you look at the opinions that piecemeal overruled Plessy, you'll see that they could engage Plessy's interpretive politics directly. But what is the court doing now? It's not doing interpretive politics. It's refusing to follow any of the norms of justification and explanation. Appellate courts don't make factual findings separate from the trial court. Appellate courts don't decide that the facts of the world are different than the facts of the world stated in the legislation that they're interpreting. Well, look when the court overruled large portions of the Voting Rights Act. They just said, hey, this isn't a problem anymore. Where'd they get that from? They just made it up. Racism's not a problem anymore. What about the norm of factual justification? It doesn't exist anymore. Just pull from anywhere you want to it's not just bad law, in other words. It's not law anymore. There's nothing wrong with being an activist. That's a stupid distinction. That's a kind of a meaningless nonsense thing to say. Judges make law, but there's a process by which they make law. They can do it badly, but they're still doing the process. That's my point. Even bad law is law because it's within the realm of shared assumptions of justification and explanation, shared interpretive norms. And the current court is just not following those anymore. They're just making it up as they go. All right. So there you go.